Hello students, I am Dr. Harpreet from Army Institute of Law, Mohali. The topic for the day is Protection of Life and Liberty of Arrested Person, a study of Article 22 of the Indian Constitution. Introduction of the topic. The protection of life and liberty of an arrested person is a fundamental principle of justice that ensures individuals are not subjected to arbitrary detention, torture or inhuman treatment. The right to life and personal liberty is the cornerstone of democratic societies, enshrined in national constitutions and international human rights laws. An arrest does not strip a person of their fundamental rights. Rather, legal safeguards are in place to ensure that they are treated with dignity, informed of the reasons for their arrest, and given access to legal representation. These protections prevent the misuses of power by law enforcement authority and uphold the principle of fairness, due process and justice. Legal frameworks such as constitutional provisions, judicial precedents and international conventions play a crucial role in safeguarding the rights of arrested persons. Measures such as the right to be produced before the magistrate within a stipulated time, protection from self-incrimination and the prohibition of custodial torture reinforce the commitment of human rights. The judiciary serves as a guardian of these rights, ensuring that no individual is unlawfully deprived of their liberty. Upholding these protections is not only a legal necessity but also a moral obligation to maintain public trust in the justice system and prevent violation of individual freedoms. Article 21 of the Indian Constitution guarantees the right to life and personal liberty, stating that no person shall be deprived of his life or personal liberty except according to the procedure established by law. This provision ensures that individuals' basic human rights are protected and their dignity is upheld, preventing arbitrary action by the state or any authority. Article 22 of the Constitution provides important safeguards for the protection of individuals against arbitrary arrest and detention. It grants right to individual in case of preventing and punitive detention, ensuring that no person is deprived of their personal liberty without due legal process. Article 22 guarantees that every arrested person has the right to be informed of the reasons for their arrest, the right to consult a legal practitioner, and the right to be presented before a magistrate within 24 hours. However, it also permits preventive detention in certain cases but imposes restrictions to prevent misuse, such as limiting detention without judicial review to a specified period. This provision balances individual liberty with national security and law enforcement needs while ensuring that fundamental rights are protected against unlawful detention and abuse of power. Now, coming to Article 22 of the Indian Constitution. Article 22 of the Indian Constitution provides protection from and against arrest and detention in certain cases. The 7 clauses of article has been explained. Article 22 clause 1 provides that no person can be arrested or detained without providing the reasons for the same. The person is also entitled to consult or be defended by the legal practitioner of his choice. Article 22 clause 2 further provides that the person arrested or detained in custody must be produced before the nearest magistrate within 24 hours of his arrest or detention. This time period does not include the time taken to travel from the place of arrest to the court of magistrate. Further, it provides that no person can be detained in custody after the above mentioned period has passed without the permission of the magistrate. Clause 3 is an exception to Article 21 Clause 1 and Clause 2. It states that the said clauses are not applicable to an enemy alien or any person who has been arrested or detained under any preventive detention law. Article 22 clause 4 provides that no person can be detained for more than 3 months under any law relating to preventive detention unless it has been opined by the advisory board that such detention is justified. As per Article 22 clause 5, it is mandatory to disclose the grounds of arrest or detention to the arrestee or the person detained in the custody. The person must also be given an opportunity to make representation against the order of his detention. Article 22 clause 6 states that the detaining authority is empowered to not disclose the facts that are against public interest while disclosing the grounds of arrest or detention to the concerned person. Under Article 22 clause 7 lays down that the Parliament has been empowered to prescribe circumstances or classes under which a person may be detained for more than 3 months without obtaining any opinion of the advisory board. Maximum period for which a person can be detained under preventive detention laws, and third, procedure to be followed by an advisory board in an inquiry as per clause 4 of Article 22. Now, I will be discussing with you objectives and applicability of Article 22 of the Constitution. Article 22 embodies certain procedural safeguards against arrest or detention within its scope. These safeguards help in avoiding any miscarriage of justice by acting as a kind of check and balance on the powers of police officers, making arrest and authorities empowered to detain a person. Article 22 also lays down certain rights available to a person who has been arrested or detained. These safeguards are available to all people, irrespective of whether they are citizens of India or not. This is because the right to equality is granted to every person, whether citizens or non-citizens, and these safeguards must be also available to all. However, it cannot be availed by any enemy alien, that is a national of any country with whom India does not have friendly relations. These are applicable to all arrests except those made under a warrant issued by the court. The warrant must be issued upon an allegation or accusation of an actual or suspected commission of an offence, or there must be an apprehension of commission of an offence by a person. The offence can either be criminal or quasi-criminal in nature or any activity prejudicial to the interest of the state. However, these safeguards are not applicable to a person arrested or detained in a civil matter. For example, a person arrested to recover land revenues cannot avail these safeguards. Another exception to the applicability of this article is when there is no allegation or accusation of any actual or apprehended commission of an offence by a person. Preventive detention in India, Article 22 provides protection from arrest and detention in some cases. Despite this, preventive detention is allowed in India. In order to understand Article 22, let us first delve into the concept of preventive detention, circumstance under which it can be allowed, and its history in India. The concept of detention as a punishment is not new to India. Its existence can be witnessed since India was a colony of England. The Bengal Regulation 3 of 1818 and similar enactment in Madras and Bombay laid no fetters on the power of the government to detain a suspected person. Rule 26 of the Defence of India Act 1939 authorized the government to detain a person upon satisfaction that such detention is necessary to prevent the person from carrying out any prejudicial or illegal activities against the defence and safety of the country. This was based on a legislation enacted in England during World War II, whose validity was also challenged and upheld by House of Lords. The practice of the preventive detention continued in India with an aim to suppress breach of public order, public safety, etc. The framers of the constitution realized that the circumstances which led to the enactment of such legislation related to preventive detention in the past have not disappeared after independence, and therefore it was felt necessary to continue with it. However, it must be subject to certain safeguards. In order to prevent the country from anti-social activities and subversive forces, the power of detain a person in custody was conferred upon the state. However, this power was subject to certain constitutional safeguards which, if violated, remedies can be sought by approaching the Supreme Court or the High Courts. These safeguards are known as fundamental rights which must be enforced, and if not, constitutional remedies can be sought. Now, meaning of preventive detention. Detention is of two types, punitive detention and preventive detention. Punitive detention is used to punish a person who has already committed an offence, while preventive detention is used to prevent a person from committing an offence or from carrying out illegal activities. A person is detained before he commits an offence as a measure of precaution. In this situation, neither any charge is framed nor any offence is proved, but there is a strong suspicion and a reasonable apprehension that the person might commit an offence. If a person has been detained in a custody without trial, it is known as preventive detention. The objective of punitive detention is to punish a person for commission of an offence after the trial. Preventive detention seeks to prevent a person from allegedly committing an offence or an illegal activity in near future. Preventive detention takes place in case there is an apprehension that the person may carry out prejudicial activities against the security or integrity of the state, public order, defence, etc. if not detained. This kind of detention is used wherein the authority has no sufficient evidence to make charges against the person, but can satisfy and justify his detention on the ground of suspicion. The difference between punitive and preventive detention lies in the fact that constitutional safeguards are available against preventive detention. Such laws which restrict the freedom of person must be exercised with due caution and as an alternative to ordinary laws. In a leading case of SP Day versus Union of India of year 2014, it was held that absconding is not a ground for preventive detention and no order can be made for the same. Further, in case of A.K. Gopalan versus State of Madras 1950, the court highlighted the need for such a provision and held that it has been included in the Constitution of India in order to prevent the abuse of freedom by anti-social activities. However, certain safeguards have been provided under clauses 4 to 7 of Article 22. The Honorable Supreme Court in case of Hardan Saha and another versus State of West Bengal year 1975 held that the principles of natural justice are to be considered while determining reasonableness of restrictions with the application of Article 19. If all the principles of natural justice are excluded, the court cannot ignore it. Thus, the detaining authority as per Article 22 clause 5 is under a duty to give fair consideration to any representation made by the detainee. Rights of an arrested person. Article 22 under clause 1 and 2 provides certain rights pertaining to the protection of life and personal liberty available to a person during his arrest. These are right to be informed of the ground of arrest and right to consult a legal practitioner, right to be produced before the magistrate within 24 hours of arrest and freedom of detention beyond the specified period of 24 hours except when ordered by the magistrate. The first right is right to be informed of the grounds of arrest. Article 22 Clause 1 provides protection against the act of executives or other non-judicial authorities. The two conditions for the applicability of this clause are: the person must be arrested or should have been arrested other than under a warrant issued by a court, and such person must be taken into custody only on an allegation or accusation, suspension or apprehension of the commission of the offence. It further provides that no person who has been arrested can be kept in custody without being informed of the grounds of his arrest in language that can easily be understood by him. Thus, it is necessary to inform an arrested person of the reasons behind the same. However, it must be noted that the term arrest and detention under Article 22 does not include civil arrest within its ambit. In case of Ratan Singh versus State of Punjab, EIR 1982 Supreme Court, page number 1, the Honorable Supreme Court held that even if the detainee is a smuggler, the safeguards cannot be denied to him, despite the fact that he committed an offence prejudicial to the economy of the country. Similarly, in case of Ramchandra A. Kamath versus Union of India, EIR 1980 Supreme Court 765, the court held that a document which has been referred while deciding on the grounds of arrest must be furnished to the detainee. If there is a delay in doing so, it cannot be said that the detention was according to the procedure established by law, and thus right to make an effective representation is denied. It can be concluded that detention of any person can be vitiated if following are not supplied to the detainee. First, documents referred by the detaining authority while forming the grounds of detention. Second, documents which are important and vital even though not considered by the detaining authority. Next right is right to consult a legal practitioner. Article 22 also provides that a person who has been arrested has a right to consult a legal practitioner and be defended by him against such order of detention. This is mandatory in nature as observed in case of A.K. Gopalan versus State of Madras, EIR 1950 Supreme Court, page number 27. However, an exception to this rule is that representation is excluded by law in a civil litigation. Initially, courts were of opinion that providing legal assistance to an arrested person is not mandatory. However, the Supreme Court in a landmark case of Husainara Khatun versus State of Bihar, EIR 1979 Supreme Court 1369, held that an accused person who is not in a position to engage a lawyer must be provided free legal aid by the state. If it is not provided, it would amount to a violation of Article 21 of the Constitution. In a leading case of Joginder Kumar versus State of UP 1994 Supreme Court cases, page number 260, it was held that friends and family of the person arrested must be informed of the grounds of his arrest or detention. This must be informed by the police officer carrying out the arrest. An entry has to be made in the police diary regarding those who have been informed about the arrest. The court, in a case of Chaluvik Govada versus State 2012, observed that due process of law incorporated in our constitution means that a person must be given an opportunity of being heard before being condemned, and such opportunity must be fair, just and reasonable. Next right is right to fair trial. Right to fair trial is a right which is available to every person undergoing a trial, irrespective of whether he is innocent or guilty. Moreover, a person is presumed to be innocent until proven guilty beyond reasonable doubt. This must be proved in a trial which is conducted fairly and reasonably. The provision of amicus curiae for an accused who is incapable of engaging a counsel to defend him is a measure to ensure the goal of fair trial. However, this right must not be a sham. The appointment of an amicus curiae for an accused person must not be a mere formality, but must be done in true spirit, and the opportunity of being heard be provided to every accused before being condemned. This was also observed in case of Muhammad Hussain versus State Government of NCT of Delhi in year 2012. The third right is right to be produced before the magistrate within 24 hours of arrest. Article 22 clause 2 provides that a person who has been arrested or detained in custody must be produced before the nearest magistrate within 24 hours of his arrest or detention. This excludes the time required to travel from the place of arrest to the court of the magistrate. Fourth is freedom from detention beyond the specified period of 24 hours. If the above mentioned right of the arrestee or person detained to be produced before the nearest magistrate within 24 hours of arrest or detention is violated, it would render such arrest or detention as illegal. In case of CBI versus Anupam, year 1992, and the case has been delivered by Justice Kulkarni, the Supreme Court established the guidelines regarding the arrest of an accused in case investigation is not completed within 24 hours. The Supreme Court held that judicial magistrate can authorize the detention of the accused either in police custody or judicial custody, and total period of such detention cannot exceed 15 days. After the detention, the person can be remanded in judicial custody only. However, if the investigation is not completed within 60 or 90 days, then the accused will have to be released on bail as per section 187 of Bharatiya Nagrik Suraksha Sanhita 2023, which was earlier under section 167 clause 2 of Criminal Procedure Code 1973. This period of 60 or 90 days will have to be calculated from the date of detention rather than the date of arrest. However, two exceptions to the above rule as given under Article 22 clause 3 are an alien enemy, a person arrested or detained under preventive detention law. The next important case is a case of N. Sangodan versus State of Tamil Nadu 2013. This court held that the preventive detention laws of the state must be in accordance with the mandates of the Constitution. The investigation carried out under the Act cannot override or trample upon the provisions mentioned in the Constitution by any malified act. This would amount to abuse of power. Now, right of detainees. Article 22 clause 5 grants two rights to a detainee: a ground for detention to be communicated to the detainee and right of representation against the order of detention. First is ground of detention. It is the right of a person who has been detained by any detaining authority to be informed about the grounds on the basis of which he has been detained. This must be done at the earliest. The grounds must be such that authority is satisfied that it is necessary to detain the person. In the case of Vijay Kumar Dharna versus Union of India, AIR 1990, Supreme Court 1184, the appellant was served with an order of detention in the English language. However, he was only familiar with Gurmukhi, due to which he was unable to effectively make representation against the order of detention. The Supreme Court held that because of such variance, the appellant was unable to understand the ground of his detention and further represent against the order, which was a denial of his right under Article 22 clause 5 of the Constitution. In case of Union of India versus Salina 2016 Supreme Court cases, page number 437, the court reiterated that detainee must be informed of the grounds of detention at the earliest. However, in case of Gautam Jain versus Union of India, recent judgment of 2017 Supreme Court cases, page 133, the court held that where the order of detention is based on multiple grounds independent of each other, the lack of supply of a document pertaining to one ground for detention cannot vitiate the order due to applicability of the principles of severability. Next is right of representation. Another right provided to the detainee is the right to make representation against the order of detention. This right cannot be exercised if the grounds of detention have been informed to him vaguely or if the grounds are irrelevant or insufficient. The appropriate authority is under an obligation to provide the detainee an opportunity to make representation against the order of detention at the earliest. The representation must be considered independently by the appropriate authority, and there should be no delay in considering such representation. If the advisory board opines that the detainee must be released, the detaining authority is bound to release him. Concluding my topic, I can say the Indian Constitution is the living law of the land and is considered as the grand norm from which all the laws and regulations framed or to be framed in the country finds their origin. It protects and guarantees the fundamental rights of the citizens without any discrimination. The Constitution also provides certain rights to the accused or persons who has been arrested or detained due to alleged commission of an offence. Article 22 is one such provision which lays down rights against arrest and detention. It is in consonance with the human right mentioned in the Universal Declaration of Human Rights. In conclusion, Article 22 of the Indian Constitution serves as a crucial safeguard in protecting the right to life and personal liberty, ensuring that no individual is arbitrarily deprived of their freedom. It lays down essential legal provisions for the protection of arrested or detained individuals, including the right to be informed of the reason for arrest, the right to legal representation, and the requirement to be presented before a magistrate within 24 hours. These safeguards uphold the principles of natural justice, fairness, and due process, preventing the misuse of state power. While the article allows for preventive detention under certain circumstances, it also establishes limits and procedural safeguards to prevent its misuse. The right to life and liberty is the foundation of a democratic society, and its protection is essential for upholding the rule of law, human dignity, and justice. India, being the largest democracy, secures the rights of its citizens. People are the real rulers in a democratic society. Thus, it is necessary to secure the rights of those who are accused and arrested by police officers in order to ensure that no innocent person is sentenced. This is also one of the principles of fair trial. Indian legislatures and the judiciary have been successful in upholding such rights by enacting various legislations and landmark judgments from time to time. The need to do so was felt due to an increase in the number of custodial deaths, rapes, and tortures. However, the situation is yet to improve. Incidents like these go unreported, and thus it is necessary to regulate the powers of the officers and authorities. That's all for today's talk. Thank you and have a nice day.